So the Home Office has genuinely argued at the Court of Appeal that the rights of asylum seekers are more important than the people of Epping, as it desperately tries to overturn this injunction and argue against this case brought by Epping Council with the change of use, or the argued change of use, of the Bell Hotel. So there's a number of things in here, many of which are contradictory or don't make sense, promoted by the Home Office. And I now have had the opportunity to look at the judgment granting the interim injunction. And so I'll look at that in a minute, go through a few paragraphs that I've highlighted with a few thoughts about that, on why I think the Home Office will lose this one. And it could have ramifications across the country. First of all, if you do like my brutally honest input with the law as to what goes on in the news, please do subscribe to the channel. I am independent. I will remain independent, even though I will lend my assistance to Restore Britain, as you may have noticed over on X. I remain independent, and I'm offering my pro bono assistance where I see that it is going to be valued. So thank you for subscribing, if not least for that. Oh, and if you do want my personal views on any of these things, please do check out my Off the Record channel linked below. We are soaring towards 100,000 subscribers. Thank you all so much. So let's get into this story here. So as I say, it staggers and beggars belief that the Home Office is arguing that the rights of asylum seekers are more important than the people of Epping. This is not to say that I discount all humanitarian regard for those asylum seekers and so on, but there is a strong argument that the people that live in the area have a right through its council to decide how the buildings are used and how the areas are used in that area. And that is entirely a matter for them. And that is sort of the point that's going to underpin a lot of the argument in this video. Argument which I think the Home Office is going to lose against. Now, as it's summarised here in the Telegraph, I'll link this below. You can form your own views, of course. So they argue here the rights of asylum seekers are more important than those of Epping. It's quite an unbelievable, boldly ridiculous statement, really, because they cannot possibly argue that their rights are more important, because the Home Office has essentially, to want of a better phrase, dumped them in Epping. And the council has argued that this is a material change of use. Now, there's a lot of different arguments put forward through this page here on the Telegraph. I'll leave you to read that yourself. But one of them here says, Epping Forest District Council should have considered where destitute asylum seekers could be housed, if not in the Bell Hotel. Now, respectfully, no, they shouldn't. It's not their problem. If the Home Office wants to house them somewhere, it is for the Home Office to decide where to put them. Now, obviously, at the moment, they've decided to put them in hotels around the country, and this could be the tipping point that allows councils to overturn that decision for various hotels around the country, and I suspect it could have a knock-on effect for the rest of the housing for dispersal housing around the country as well. Because there are several points throughout the judgment, which I'm going to come to in just a moment, which underpin that local planning laws is really a matter for the local authority. Now, there's been various arguments as to whether or not the rights of asylum seekers are important and whether or not it's causing local chaos in the area because they're in the hotel and so on, much of which the judge has sort of swept aside, really, and ultimately said, well, it comes down to planning and whether or not there's a material change of use, and then whether or not, spoiler alert, not, the court should get involved in deciding how those buildings should be used. So let's go to a few paragraphs in here so you can actually think of this with some level of authority. I will link it below. It's a lengthy judgment. For the haters and the trolls, I cannot possibly give you everything that is in this judgment here in what will probably an 8 or 10 minute video. So go and read it for yourself and then maybe comment on it. But for now, let's take a look. So the relevant framework is obviously the Town and Country Planning Act, and where permission is required is for the development of land, and the development for the purposes of this is where there's a material change of use. But the making of a change of use itself, as has been upheld by courts, does not in itself amount to development. It depends, and I'm looking at the highlighted portions here. Maybe I'll go bigger so you can see it more clearly. This bit here, this depends on whether the change is material in terms of planning considerations. So think about if you're going to make a change to your house or a change to a building. How does it look? How is it used? How is it going to affect the local amenity? How is it going to affect car parks and flow of traffic, flow of pedestrians, and all sorts of other considerations? How is all those things going to affect the use of the building? And therefore, they are all material to planning considerations. So the local council may say, well, no, because that makes it look out of kilter with the rest of the area there. So now I'm going to move through various paragraphs that I've highlighted and tell you why I've highlighted them. I'm doing this somewhat on the fly because there's a lot to it, so I'll just give you my thoughts as they pop up. It follows here, the court's made some arguments and said it follows that whether the current use of the bail accommodation for asylum seekers is lawful depends on the answers to two questions. First, whether such use is a change from the permitted use as a hotel, and second, whether, if there is such a change, is it a change which is material in terms of planning considerations? Because that then reverts back to the council, because they have overall say on how a building is used. Paragraph 33, the court looked at these planning matters as being one for the local planning authority and not the courts. It said at paragraph 33, at paragraph 30 of a judgment quoted, Lord Bingham explained that the importance but also limitations of the principle that matters of planning judgment are for the relevant local planning authority and not the court in these terms. And the bit that I've highlighted for you here, an application by a local planning authority under section 187B is not an invitation for the court to exercise functions allocated elsewhere. Thus, it could never be appropriate for the court to hold that planning permission should not have been refused or that an appeal against enforcement notice should have succeeded. The court went on to quote again, I certainly accept that it is for the planning authorities and not for the courts to see to the preparation and administration of plans and policies for the use of land. What uses should or should not be allowed of lands within the area of the authority, what developments should or should not be permitted to take place upon such lands, are questions for the planning authorities and not for the courts of law to resolve. So again, emphasizing here that it is coming back to planning matters and that these are the local authority to decide. Paragraph 38, it follows from the above, that the court will be in a position to assess the strength of arguments that there have been a change of use and that the change is material, provided care is exercised and provided the court remembers that the exercise is fact-specific, with the facts being matters for those charged with making planning decisions. However, the question of whether a material change of use is one for which the planning permission should have been given is in a different category. It is a matter of planning judgment within the purview of the local planning authority, subject to the planning appeal process. That is forbidden ground for the court, and that is adopting Lord Clyde's language here. The court then went on to say, in the context of this, it means that the claimant's view that the material change of use, which, on its case, has occurred is not worthy of planning permission is to be seen as a matter for the claimant and not the court. It is nonetheless to be noted that there's not yet been a formal planning decision to the effect in the way in which there would have been if the defendant had submitted an application for planning permission. At paragraph 57, under the heading of proper characterization and any breach of planning control by the defendant, the claimant says that not only has there been a breach of planning control by the defendant, the hotel, but that the breach is flagrant and that the defendant's behaviour has been surreptitious. Mr. Coppell submitted that the defendant's behaviour could be so characterised because it had indicated that it would make an application for permission for change of use and then changed its position at short notice. This sort of hinting the involvement of the Home Office to change to say, actually, no, the rights of asylum seekers are important here. In paragraph 63, getting on to talk about the injunction here, the court said the purpose of an injunction under section 187B is the restraint of a breach of planning control. The claimant, the council, in such a case, is seeking relief in its capacity as a local planning authority. Matters which are not material to the existing or anticipated breach of planning control cannot be relevant to the purpose of seeking the injunction. The court must look at the balance of convenience from that starting point or through that lens. The question of the balance of convenience cannot be addressed in the abstract or by some reference to general question of desirability. So again, coming back to the facts, coming back to the law and what the role of the council is here and what it is allowed to decide. At paragraph 107, the court, drawing things together here, said although the defendant's actions were not flagrant or surreptitious, they were deliberate. The defendant acted in good faith, but chose to take its stand on the position that there was no material change of use. The defendant did so in the knowledge that the claimant, as a local planning authority, took a different view and believed that permission was necessary. It thereby sidestepped the public scrutiny and explanation which could have otherwise taken place if an application for planning permission or a certificate of lawful use had been made. It was also deliberately taking the chance that its understanding of the legal position was incorrect. This is a factor of particular weight in the circumstances of this case. At 108, the strength of the claimants, the council's contention that there's been a breach of planning control and that the current activity is the result of a material change of use is such that, exceptionally, it is a factor to be taken into account in the balance of convenience in the support of the grant of interim relief, i.e. the injunction that the hotel must close. As to the reports and the concerns of crime and such things, the court dealt with these, commented on them at least, at paragraph 109, and said as follows: for the reasons set out above, the fear of crime resulting from the use of the bell, the need to address the lawful protests, and the consequences of the actions taken to address unlawful activity are relevant factors in support of interim relief. There are all factors of limited weight, but the weight diminishes as one moves along the list. They are, however, matters having an effect on the amenity of local residents through the fear of crime and the need to address the reactions which that use has generated. If the use continues and is ultimately found to have been unlawful, the position in respect of those matters can revert to its former state. However, and this goes to harm that can't be fixed in the final sentence here, those whose amenity has been affected in that period will not be compensated, and to that extent there is a risk of irremediable harm that can't be put right. The court commented on the claimant's submission that community tensions would continue, but the court said that amounted essentially to speculation and took no account of it. The court did say, however, that there is force in the claimant's contention that it is not inviting the court to speculate as to the impact of the amenity which might result from a future use, but is pointing to an impact on amenity which has already been suffered and is continuing. And at 116, the court reminds everybody that the breach of planning control has not been definitively established, although I've concluded that the strength of the claimant's case is such that it weighs in favour of granting interim relief, which is usually a relatively high bar. It is to be remembered that a final decision has not been reached, and it is possible that the final conclusion could be that the defendant is right to say that there's been no breach of planning control. But ultimately, that is going to be a fact determination by the court. And in conclusion, the court said in those circumstances, the claimant is to be granted interim relief, and I'll hear submissions in the form that relief should take the directions, etc. And so ultimately, the court really boiled this down to the essential points of the local authority being able to decide matters of planning and the amenity, how buildings are supposed to be used, and that the defendant really should have sought a change of use. And if one paragraph were to say it all, it would be this one here, which is a quoted paragraph 68 within paragraph 34 of this judgment. If there is one principle of planning law more firmly settled than any other, it is that matters of planning judgment are within the exclusive province of the local planning authority or the Secretary of State. The courts may consider the legality of a planning judgment, but not the merits of the planning decision. And so ultimately, the court will be tasked to make a final decision on whether or not there's been a breach of planning control. And if so, it might make this a permanent injunction against the use of this hotel in this area in Epping. And this, of course, will set a precedent, and of course other councils can rely upon this because it will be a binding judgment. Whilst it will be fact-specific, case-specific, of course it will have an impact on other areas because many other areas, whilst they will be fact-specific themselves if they are brought as separate cases, will be able to rely on much of whatever this judgment ultimately says. But at the end of the day, I remind you that the Home Office has quite clearly said in its arguments that the rights of asylum seekers are more important than those of the people of Epping. So once and for all proving that they do take their rights more seriously than the people in the local area. Now, doubtless they make the argument that they are more underprivileged and more vulnerable and so on and whatever those arguments are, but nonetheless they are arguing that their rights are more important. Let me know what you think about that in the comments below. If you do want my personal views on any of these things, do check out my Off the Record channel below and occasionally Black Belt Secrets when things don't fit anywhere else. Thank you for watching, and I'll see you next time.